Hello to all of you. I'm Bojan Podgoršek. I'm notary in Ljubljana. I'll speak about enforceability of notary acts in cross-border cases. We are talking about kinds of notary documents in Slovenia. We have three kinds of notary documents. First is, as you see in today's topic, Notary Act, but I prefer to name this document as Notary Deed. In Austria is Notariatsakt, in Slovenia is Notarski zapis. So I will use the title Notary Deed for that document. Beside this notary document, we have also two kinds of notary documents in Slovenia. One is notarial minute or notarial record or notarial protocol, which is mentioned for verifying the facts. And third is notarial certificate, which is first mentioned for certifying of signatures. So it's most common notary document in Slovenia, but it's not most important. Most important document is notarial deed, which is, as you know, authentic instrument, as all of notary documents, but only notarial deed is authentic documents which spread this authenticity to all of the content of the document. So also on the transaction, and most important is that this notarial deed verifies also that the parties of this notarial deed and the parties of the transaction have will to conclude this transaction, that they are aware of all consequences of the transaction, and that they agree with the consequences of that transaction. The notary has to make sure that all the parties are aware of these consequences, and that's also a part of authentic instrument. As you know, the Brussels bis regulation defines the authentic instrument, and this authenticity must be regarding also to the content of the deed and also to the signature. Our notarial certificate about the signature includes only signature and not the content of the transaction. So, a notary deed is very important document, but it's not almighty. It has limitations with the enforceability of, for example, conditional receivables, then receivables arising from certain banking transactions, for example, credit agreement in the form of an overdraft facility in the debtor's current account, then claims of tenants for the vacancy of apartments or business premises, because our law about our housing law and our law about business premises and business objects has a rule that enforceable is only court decision, only judgment, and notarial deed it's not enforceable, and in such cases. Actually, enforcement on the basis of notarial deed, which clearly determines creditor and debtor, in which the obligation from the debtor's point of view and claim from the creditor's point of view is clearly specified. Also, the side obligations, the principal obligations is clearly specified, maturity of the claim is specified, and the enforcement of such notarial deed shouldn't be very difficult. But I mentioned the cases and the topics where the enforcement of notarial deed has some limitations. Also, one fact which point out the power and the importance of the Slovenian notary deed. The general limitation period for claims in Slovenia is 5 years. The Supreme Court of Slovenia decided in favor of the notarial deed that receivers established by a directly enforceable notarial deed have 10-year limitation period, the same as judgments given by courts, and not only within a general limitation period of 5 years. Let me just point out the elements for enforceability of notarial deed, which can be as enforcement title. First, the obligation must be specified in the notarial deed. Then, for this obligation must be permissible settlement. Third element of enforceability of notarial deed is maturity of the obligation. And the most important element is the consent of the debtor. The debtor has to express, to clearly express consent for direct enforceability of his obligation. And he must agree with enforceability of his obligation in advance, because at the moment of concluding agreement, of course, he can agree with enforceability of his obligations, but maybe he will change his mind at the time of execution. But no matter, he cannot change his mind anymore, because the consent in advance in notarial deed is important. Today was already mentioned the regulation, which is called also Brussels 1A or Brussels 1bis. We will come back to this regulation. First, I will mention our law about notaries, Notarial Act, which stipulated in Article 7 what are the conditions or what are the elements of the enforceability of foreign notarial deed. First element is the reciprocity. I think that under Brussels 1A, this element must not be problematic nowadays with foreign notarial deeds, special for notarial deeds which were drawn up in member states. Second condition or second element of enforceability of foreign notarial deed is that it refers to rights that are not in conflict with the public policy of the Republic of Slovenia. With that element also shouldn't be a problem, because it's the only reason it's the only obstacle, as I understand as I understand this, Brussels 1 bis for rejecting the execution. And third element or condition is that it contains all the elements that are a condition for enforceability under Slovenian law about notaries. This could be problematic, as we will see if we compare it with provisions of our regulations 1 bis, Brussels 1 bis. Here in the first paragraph of this regulation is that this regulation shall apply in civil and commercial matters, whatever the nature of the court or tribunal. And there is also in further text that this regulation shall not apply to the status or legal capacity of natural persons and relationship about matrimonial relationships, then bankruptcy, winding up proceedings, social security, arbitration, maintenance, obligations, wills and succession. Article 58 is very important for authentic instruments, and which include notarial deed. An authentic instrument which is enforceable in the member state of origin shall be enforceable in the other member states without any declaration of enforceability being required. Enforcement of the authentic instrument may be refused only if such enforcement is manifestly contrary to public policy in the member state addressed. And then it's very further is interesting provision about applying as appropriate the provisions of this regulation about enforcement, about refusal of enforcement, and common provisions in section 4 of chapter 3. And let us see if we change the word judgment with word notarial deed or authentic instrument in provisions I mentioned, which can we apply as appropriate to authentic instrument. Article 40 and Article 41 are here on the table. An enforceable AI shall carry with it by operation of law the power to proceed to any protective measures also, which exist under the law of the member state addressed. Then, subject to the provisions of this section, the procedure for the enforcement of AI given in other member states shall be governed by the law of the member state addressed. And AI given in a member state, which is enforceable in the member state addressed, shall be enforced there under the same conditions as authentic instrument given in the member state addressed. And Article 45 and Article 46, which were already mentioned today, stipulates the only reason for refusing the enforcement of judgment, or here in our case, authentic instrument, and this reason is if such enforcement is manifestly contrary to public policy in the member state addressed. And also one very important article in Brussels 1 bis for the enforcement of the authentic instrument is Article 52. Under no circumstances may authentic instrument given in a member state be reviewed as to its substance in the member state addressed. If you remember our Article 7 in our Notaries Act, which stipulates element for the enforcement of foreign notarial deeds, is that it contains all the elements that are conditioned for enforceability, which are stipulated in Slovenian law. Then Article 58 is also important. The authentic instrument produced must satisfy the conditions necessary to establish its authenticity in the member state of origin. According to Article 60, the competent authority of court or court of the member state of origin shall, at the request of any interested party, issue the certificate using the form set out in Annex 2, containing a summary of the enforceable obligation reported in the authentic instrument or agreement in the court settlement. Here is Article 42A of our Enforcement and Security Act, which regarding to Brussels 1A, which is also mentioned in this article, stipulated that the certificate of enforceability of authentic instruments on the basis of Brussels 1A and other regulations shall be issued at the request of the party by the court and so on, and also by the notary who has drawn up the the authentic instrument. Let us, for the clearly picture of this, just briefly look at this form in Annex 2 of Brussels 1A. First, it's description of authority issuing the certificate, then is description of authentic instrument, notarial deed. The point 3 is description of court settlement, which is not the case in our topic. Point 4 is about parties to the authentic instrument, debtor, and the creditor. And most important, I think it's point 5, which is about certificate. The authority issuing the certificate certifies that the authentic instrument is enforceable in the member state of origin. Then we have different points. Yeah. I'm nearly finished. The 5.2.1 is a description of monetary claim, and the 5.2.2 is description of non-monetary enforceable obligation. So thank you for listening to me. That's my contribution.